Good afternoon, everybody. It's Andrew here from andrewplummer.com. Today I have a very, very special guest, Paul Brennan. Whilst I've known Paul for a few years, I did look at his bio on Amazon today and realised that we'd probably be better off shooting a 10-part mini-series. But anyway, we're here. Paul's a solicitor on the Sunshine Coast, and like I said, I've heard him talk many times, and he's a real character. So welcome to the show, Paul.
Thank you very much.
Paul, firstly, maybe I'd like to know a little bit about your past. Maybe tell the listeners a little bit about where you come from and what brought you to this place where we are today.
All right. Well, it's quite a long story. So I started off in London. My dad was a policeman, and he was at West End Central. And my mother died when I was
11.
Oh, about 10.
Okay.
And my dad died about a year later. He drunk himself to death. And so consequently, when I talk about wills, I kind of know a bit about this. And what tends to happen is that when there was my brother and I was 10, he was 14. And there's a lot of offers being made, but once the funeral's over, a very large funeral, then people tend to step back because they have their own children and their own responsibilities. So with me, it was my grandmother stepped in, and also my uncle, who was a commando in the war. And we at 10 and 14 didn't give them any sort of credit for taking over this responsibility. And what we did is we acted like sort of children of 10 and 14 and made my grandmother's life a bit of a misery, really. I remember putting a rat in her shoe one day. It's that sort of shooting all the windows out with a bow and arrow and those sorts of things. But why my uncle didn't stab us, having been with his history. But we got through that. And at the age of 16, I left home and became a police cadet because my dad had been a policeman at West End Central. Yeah. I did that. It was not a great choice because at school I wasn't academic at all. In fact, one report said I was lazy, talkative, and notable. And for a while I thought notable didn't sound too bad until I realised it actually said not able. And so the idea of me going off to be my physical education instructor wrote in my report, physically immobile. And in those days, people were pretty frank in your reports. Now I'd get probably, you must be very proud of him sort of thing. Anyway, so at 16, I went along, and I remember the first day on the assault course being a sort of a military, because it was sort of half academic and half sort of sport, this course, police cadet. And I remember being on the assault course and actually sort of starting to feel a bit tearful, actually, because I couldn't get over the 6-foot wall. But they actually turned me in about a period of 6 months into a sort of a person who was average. And they did that by saying, "Shut up, love yourself," which obviously is good advice for me today. So I can carry on. It's a very, very long story.
That's great. So you've obviously you were a bad boy at one stage. And
hopeless, I would think.
Hopeless. And you've obviously come a long way. You're a published author. I at last count 9 books, which is pretty unreal. So, and I'm currently I've read this book here, The Law is an Ass, Make Sure It Doesn't Bite Yours, which I found very interesting. And I just noticed out on your desk that another book, 10 Mistakes Businesses Make or Shouldn't.
So the idea with all my writing is to try and, some of my writings directed at clients, some of my writings directed at lawyers. To clients, it's basically that book, which is my second book, which basically said the law is an ass, okay, fair enough, but you've got to make sure that it doesn't bite yours. And so the idea is that let's just not stand back and say it's an ass. You've got to do something about it to protect you. And there's certain things you can do. So the 10, when I wrote the 10 biggest mistakes in business, the idea was to say, okay, here are the 10 things you shouldn't do in business. And I've done 10 things that people shouldn't do. Like, for instance, you shouldn't fall out with your neighbours. For instance, you shouldn't lend money to people. And if you do have to lend money to people, then make sure that it's the money is secured by something and at least documented. If you can't do anything else, then just get them to write you out a check with that money, and which you can actually sue on the check. And it means you don't have any of the hassle. So there's a number of things that people should know, and I'm not saying they should know about the law. Being a lawyer, I wrote a book about intellectual property, and this book was a very, very thin book, deliberately so, because if all I need to do would be to put in one case in that book, and that would be sort of 50 pages on its own. So it's not difficult as a lawyer to come up with a lot of information. The problem you do find as a lawyer is it's difficult to write a book without putting everything in it that you know. And in some ways, the less you know when you write, the better, because, you just can never finish, and you have to keep telling people things and making it very, very long. Whereas the idea, the object I have, not maybe in this conversation here, but generally is to try to give the bottom line. And if you get to a place where you need a lawyer, then you have to know when that is.
Keep it simple. Would
That's
that be?
the idea.
That's the idea.
That's the idea.
And then that's what I found about this book here. Very, very simple. It's sort of common sense almost. But obviously people don't follow.
No, otherwise we'd be out of business. So for all these centuries, people haven't followed the advice. But I think that and what happens is lawyers are in the great position that we actually get to say to people, in the matter of hindsight, that you shouldn't have done this or shouldn't have done this. But I think if your lawyer concentrates too much on that, you've got to get rid of them. But basically, you get that idea. You come up problems after the event.
Mm-hmm. So I heard you talk the other day about wills, which was very, very interesting. Is this going to be another book, is it? Or?
I've actually written stuff on wills already. So I wrote one called The Legal Guide to Dying, Baby Boomers Edition. That was about in 2008. So obviously we've now had another sort of 8 years moving on. And it was a very unpopular book. It was an e-book, actually. It was a very unpopular one. People just didn't really want to sort of address the issue, and people don't. It tends to be, as a lawyer, you tend to get some sort of death in the family or something, and all of a sudden people are interested in making a will. Before that, often people just don't make it. I would guess about maybe 50-60% of people don't make wills. And if
so in the event that somebody doesn't write a will, what's the process? What's the process then that your next of kin would have to go through to make a claim?
Well, it's not so bad, really. There's the law of intestacy, because the law has been going up this a tremendous amount of time, and therefore they've got certain sort of ways of dealing with things. So there's like a shopping list, and if the money is left to, first of all, it would be to maybe your closest relative. It would be sort of maybe husbands and wives, children.
De facto wives.
De facto wives. Well, unfortunately, because lawyers drafted, there's separate laws in each state and each country, we tend to sort of mess around with this a bit. But basically the idea, say in Queensland, would be that your wife would get the first $150,000, and then it would be divided between you and the children, or her and the children. Or de facto wife would get something maybe if she claimed. But remember, a de facto wife has to make a claim in order to claim against your estate. So it's not a bad idea. Obviously, after 2 years, they do have certain rights, but they have to actually claim about it. So it'd be much easier to marry them or give them a will.
So I'm in a de facto relationship. So she wouldn't, even though I might want it that way, I'd need to document it in a will for her to.
I think you should, because what she would do instead would be to start to say, okay, we've been a de facto for 2 years, and therefore there's a certain claim that I could make. But to say, for instance, I don't know what your assets are. Maybe if it was joint property, then that actually goes outside the will. So if you owned a house jointly and it was joint as joint tenants, then it would go automatically to her. That can also cause a problem that you've got matters which don't go within the will. For instance, superannuation does not go in the will. It's a separate bucket, and therefore you have to make sure it's to the right person. Because, say, for instance, you left money to your children equally, but also there was a superannuation fund, then if you haven't made a binding nomination, the trustees there could decide to give it in a different way.
Right, right.
So you should direct it all to your will so it can all get in one bucket and go to the people you want.
But the safest bet, obviously, is to write a will.
It's a sensible thing to do, but I must say that I've had this case recently where a person was called in to look after an ageing aunt, and the ageing aunt, in the end, didn't leave them any money. And obviously, in hindsight, the best advice would be is that didn't leave any money, but you actually badgered this person into mail. She was badgered into making a will, and when she made a will, she left it to someone else, including a charity. So if the person that I know had just left it without a will, then they were on the list as a niece, one of the only sort of nieces and nephews, and they would have received the money. So it's not always a good idea to tell people to make a will.
So, I mean, we'll go through this quickly, the 10 Commandments.
Yep.
But what's the story? Like, I heard a story the other day where a guy had lived with this lady for, obviously don't know the case, nor do I really, but it seemed quite interesting. I think he'd been living with her for 3 years, had a child. She'd been in 4 relationships prior and sort of did very well out of each relationship financially. But he was basically booted out of his house. There's always another side, I'm sure. But what's the time frame that you know, where if like in a relationship, what's the time frame for the other person or the person to have the rights to an equal share or whatever it might be?
So if a person's dead.
No, I'm talking about if I'm in a relationship, a de facto relationship. So let's say I hook up with a girl, and what time frame is it that she has a right to sort of...
I tend not to do sort of matrimonial law, but it's in Queensland anyway, it's 2 years. If 2 years, all of a sudden they start to have you're a de facto. But you'll have to speak to someone who does that. I'm afraid that we've all got our own expertise.
I've got no problems, but I was just interesting to hear this one.
I might expand my practice.
Okay, let's quickly go through the 10 Commandments of will disputes. I know I've heard you talk about this a couple of times, but I found it really fascinating. So let's start at the start.
Sorry, number one, I should have a look at the list here. Let me have a look. Okay. These are the 10 things that go wrong in will disputes, okay?
Right.
And the first thing is that if you leave someone out of your will entirely, then they're more likely to make a claim today. And that is because there's a lot more, people are just more savvy about it and they're aware of rights. So what your solicitor or your lawyer will be advising you to do is even the people that you don't want in your will, if you've got an obligation to them, like it's children, then really you should give them something. And often you can see in wills there are $50,000 left to one child and the money's given equally to the other children because they're trying to encourage that one child not to make a claim.
Right.
Number 2?
Yep.
Okay. The next thing is, and these are the very sort of small points that you need to know, mediations work. When I started, then we didn't seem to have mediations. We sort of commenced an action and left it in the cabinet for 3 years and it came out. But even then, about 99% of matters settled within the very sort of almost on the court doorsteps, or often on the court doorsteps. And so the idea is that mediations brought it forward. So normally people will not have successful mediations if they just try and go in straight away. Maybe that's an simplification. Often they need to spend some money first, then they go into a mediation, and then the matter will get settled. It's often
to spend some money with the lawyers.
Often, say in will disputes, there are deep family issues there, and often people like to have a bit of, or do have a bit of a sort of an argument first, and then at some stage the procedure in Queensland puts them all in before they go to court into a room and tries to solve the matter in a mediation. And these are very, very effective because the idea is that you can either you can get back into your trenches after this and carry on fighting, or you can have it finished that day. Sometimes mediations will finish on the basis of, the car park's closing or the traffic going home is pretty bad. But whatever happens in mediations, they do often sort of fix a situation. People, from a mediator's point of view, a twisted point of view, is that everybody leaves dissatisfied and he's sort of done his job, but it's over for that day. The perfect end to a mediation would be that your opponent sort of walks out the door and gets knocked over by a bus. But that just doesn't happen. But mediations work.
Yeah. So the Queensland law is vastly different to other states, is it? Or
it's not really vastly different, because what happened is that the British Empire spread sort of the British sort of common law all over to America as well. When we watch TV on America, you watch a sort of a crime drama or a court scene there, and you'll see that it's very, very similar to the UK. But it does differ, say, in Europe. Say, and I know that in South Australia, I think they follow sort of a quite a different law down there, I think, anyway, I'm not quite sure. So, but the rest of the time, even in countries like in Hong Kong, in New Zealand, it's all sort of the British common law. In Malaysia, it's all the British common law. So it's very, very similar, but there are slight twists.
Yeah.
And one word can change the whole thing. And especially with wills, one word can be the difference between getting $1 million and not getting $1 million. So it can be important.
So I know we've got a lot to go through, but just quickly, percentage-wise, how many wills are disputed?
I have no idea. I would say, as a lawyer, I'd say not enough. Really, that's the. But lawyers tend to get it in the neck when a will is disputed. It's the one thing you can get free off a lawyer, and that is that when the will is disputed, the lawyer can be asked for a statement of what happened, and they have to write that out and give you that for nothing. So there's a bit of a cost saving there. but not enough, I would think.
No worries. Let's move on to 3.
Oh, number 3. Okay. Bad conduct must be pretty bad in order to exclude someone from your will. So don't just think that because your child or whatever is the black sheep, then the court will agree with you. And all you do is you leave a mess, and there tends to be an argument. So if you do have someone that you want to disentitle from your will, then you've got to do it properly. You've got to do it with a statutory declaration, because the idea is you won't be around at the time. The good news is that you won't be cross-examined about your statutory declaration, but the court will look at it and determine what to do. But the cases show that people who have been, like adultery, that's okay. No one gets thrown. So people make claims against wills. That will not be a reason they won't be able to claim against your will just because they've been unfaithful to you, which is surprising. Maybe if they've been really unfaithful, or maybe they've done something outrageous, but generally unfaithfulness seems to be okay with judges. The second thing, let's say, for instance, abuse. There's been a case where somebody's written a sort of a 3-page letter to a parent on their deathbed, and still they were not disentitled from the will. Now, it might reduce it down, but you're not going to get them thrown out. So really you need to dot I's, cross T's, get that statutory declaration of what happens, because often if there's someone to blame when you're gone, it will be you as far as the factual situation's goalposts move. So if you're serious about disentitling someone from your will, make sure you get the stat dec going whilst you've still got your marbles.
Wouldn't most people sort of accept the will and accept the wants of the person that wrote the will, or is that not the case?
Well, it depends. If you're inheriting, then you do really want to have your mother's wishes followed. But if your mother's decided turned against you because you didn't call her often enough and has not given you anything, obviously you don't believe that she was in her right mind. So that's what happens a lot. Like people with disputes, they tend to line up like 2 football teams, 11 aside, depending on which side their bread's buttered. That's just human nature. And there's nothing worse than in families, because the issues have been coming for years. It's like a very slow-moving goods train. You can all see it coming. And we can all play at this because we're all in families and we can all see the issues there. I always think that in a family, you've always got the uncle who's hated, the ne'er-do-well uncle who's got the $400,000 house everybody hates. Well, it always occurred to me that if you can be nice to that uncle, then you've got a good chance. And the more hated he is, the further you can be up the list if you can put aside the argument, the bitterness of the years.
It's all very sad, really, isn't it? But I guess that's how...
I think it's life, really, isn't it? But I think there's a certain sort of Disneyfication. The Disney have got a lot to answer for, because what they've done is they've told people to expect that everybody can join hands and walk together. And so families are all together. But in fact, in families, everybody has different positions. Like, say, a woman would move through being the daughter-in-law to be the daughter-in-law who sits on the couches and watches sort of adult afternoon TV and smokes cigarettes and eats chocolate, to the mother-in-law who's this old harridan, and she can be both of those. And so, or she can be the stepmother, the horrible stepmother, or she can be the daughter who's defending the father against. She can play all these roles, sometimes all at once. So people's roles in families are different, their interests are different, and therefore they should think about taking some sort of advice. And that's the thing, that if you're in an issue, a situation which is going to turn to an issue, then why not speak to a lawyer just to find out? And don't do this meeting a lawyer in the street and just saying, hey, I've got this issue. Go to his office and sit down, have him consider it.
So what about the $40 will kits?
I'm not. Well, I guess as far as creating a source of revenue for me, they're a very good idea. But it's just the whole thing that if you do a $40 will kit, you really are saying, if you're a lawyer, say if you're left out of a will, and the person who's left you out does a $40 will kit, you will say, yes, that's what happens.
Right.
So it's not a good idea, and you can make a lot of mistakes.
Okay. Moving on, number 4, I think we're up to.
Number 4. Okay. I think I've actually answered this before. A will's not always the answer, and the idea is that when I said about the person who lost out because a will a will can direct the money away from you. A will, if you're in a family, then if as the person gets older, a lot of the family members will die off, and eventually, if you can live long enough, you are probably the person who's under law of intestacy who's going to inherit. And however, if that person makes a will, then it can direct the money away from you. And the trouble is that the longer the person in their life waits to make a will, the stranger the ideas can be, the more people to influence them. And quite honestly, the more money a person has got, then the more people who seem to turn up, the more neighbours, the more 18-year-old blondes in opposite the aged care facility to take that money. So really, you've got to think about this: is the will right? The worst thing that can happen is if somebody makes a will and they don't tell you what's in it. That's a very bad sign.
Right. And how often should we be updating our will? Well,
it used to be sort of a general sort of unwritten understanding that people would make a will and solicitors wouldn't charge them very much for it, and then they promptly drop dead. But that doesn't seem to happen anymore, and people pay a lot more for wills and advice on estates now. And really, you should be looking at the main thing with wills is really, what is the issue you're facing? If you have got children and those children are under 18, you should have a will, because you should put in that will who you want to be the guardians.
Right.
That is just of such paramount importance from my own position, is that I can tell you now that if you don't do that, how do you expect other people to decide when you can't decide yourself who should be the guardians for your children? So that's serious. But if you've got no money, then really, who cares? There's very, very few legal issues in a poor man's estate, so we don't have many arguments about that. So if you've got no money, it doesn't matter. But most people nowadays do seem to have money somewhere or other in superannuation, in their house or whatever. So it's not a bad idea to set down where it's going to go, and don't rely on it'll be all right, because you can leave such a problem with your relatives if you don't specify where the money's going to go.
Sure. Okay, moving on. Number 5, I think we're up to.
Okay. Mental capacity is much harder to prove than you think. Now, look, if someone leaves you out of a will, then you will think that they're nuts, okay? Well, that's very hard to prove, because the courts have a general presumption that the person who makes a will is sane. So although you know that they've been describing themselves as Napoleon and things like that, the courts will not necessarily accept that. So nowadays, people live that much longer. They are forever going to doctors, especially as they get older, and they're forever, you lose your car keys. Does that mean that don't have mental capacity? Most people lose their car keys at one stage or other. But as you get older, these things tend to happen quite often. Like, for instance, I've had cases, for instance, in your death certificate, probably a lot of people nowadays have dementia. Dementia for years is quite a common thing. The courts don't really put much sort of emphasis on that. if someone's left you out of a will because they've been acting a bit strangely, you will think that's a great sort of thing. In fact, the courts will say, well, that's okay. You will have people saying, oh, I remember this time she was so confused, we found her in the street or whatever. It tends to be the older ladies who need to outlive everybody, as I've just found. Because she was in the street, she was wandering around in her slippers. Well, the court will say that doesn't necessarily mean that she'd lost mental capacity. Mm-hmm. And so you will come up with things. You will say, okay, she couldn't do this, she couldn't do that. She went to often what happens nowadays is that you'll get a letter from a doctor to say this person has mental capacity. Well, the courts won't put too much emphasis on that either, that she actually has the mental capacity, because unless the doctor has looked at the legal definition of what it is. So there are issues here. You've got to, if you're trying to strike a person's will out because they don't have mental capacity, the court will not do this very, very lightly. They do want it to be the attention, and people often may have some very, very strange ideas, especially as they get older. So it's difficult. But some of the things that you look out for if you're trying to create the suspicious circumstances to say that the person didn't have the mental capacity would be, say, for instance, you've got a carer receiving a load of money. I had some carers recently who, and I guess that allegedly anyway, I think the person died before they'd actually extracted all the money from this person, so therefore they decided to write the will themselves, and it was a forgery. So you have a carer get some money that might be suspicious if it's a large sum of money. It differs from wills before. If you have, say, for instance, a person going down to the solicitor's office with the person and sitting in when they make their will, that might be a bit, and they earn all the money, that's a bit suspicious. So there are suspicious circumstances. Once they're raised, then the court will apply a particular test. And that test is that, first of all, they knew that they were making a will. Most people pass that. They knew how much money they had. Often that can be a bit of a question mark, that people actually know how much money they've got. Then 3, they know who it's going to be left to, who should get some money. And 4thly, the strength of those claims. And if they can pass that test, generally the court will say, okay, that will stands. And the big kicker, if you're trying to get a will set aside, is that the court will say, well, maybe the will was made during a lucid interval. You can be a bit crazy, but you can also have lucid intervals. So therefore, although a person may make a will, as it happens quite often in June, and then in November they're admitted to an aged care facility, and in one case couldn't even sign the form because they had dementia, the court will say, but the will, from the circumstances, looks like it was made in a lucid interlude, and they will allow it.
Right. Okay, interesting, very interesting.
Okay.
And number 6 or 7?
Yeah, okay. All right, the
It's okay.
Shall I carry on? Okay. The will only covers the assets of the estate. We've actually talked about this before, so make sure that you're actually dealing with all your estate, the superannuation, the joint assets. Joint assets not included in the will. Number 7. Okay. Promises made outside of will. If you've seen the Monty Python film, Monty Python Holy Grail, there's a part in it where the Lord of the Manor takes the son to the window and says, "One day, son, this will all be yours." And he says, "What, the curtains, father?" Well, that's a very good example of a promise. And if you make promises like that, then you have to be very careful, because that can be enforced even though you don't leave your money in your will to your son. Also, if you make a promise like that, or it's one's made to you, you should write it down because it might be good. Now, these promises it's called equitable estoppel. It's a very neat name, but these promises apply to situations where, say, a farmer has a child and he works all his life on the farm, and the father leaves it to someone else. That guy has a claim. It's unconscionable to allow somebody else to get that property when that son's worked on that farm. Now, the father has to encourage him, but then there's the situation where you have the wife, so the daughter who cares for the mother all those years, and then the mother leaves all the house and everything to someone else. Well, again, that's a situation where equitable estoppel will step in to make sure that the house goes to the daughter. And the other thing is where, say, maybe you get a property managed by somebody and they do all this work on the property and then you leave the property to someone else. Again, the law is going to step in. So you have to be careful about those promises you made, but it has to be clear. Like, if your drunken promises don't really count.
But a bit of verbal promise counts. I mean, I can understand those two scenarios that you just mentioned then about, if you're working on the farm all your life and the father dies and gives the money to somebody else. I think that's
fair enough.
Fair enough, yeah. And likewise, the example you gave with the daughter looking after the mum. Yeah.
But a lot beyond that, obviously what the law is just trying to do what's fair, because we all believe that a person should leave their money to whoever they want. The will should stand. But these are the exceptions. And what the court tries to do is balance it up, that, where there's a general injustice, they give your money to someone else.
Okay, number 8, I think we're up to.
Just a note here, a will can be changed after you lose your mental capacity. So often this is just terrible that the actual court would step in and change your will. You made it with 2 witnesses, it's there. But there's been one particular case recently, if I can tell you about this, a man who 79, he has divorced his wife and his first family, and he goes to a dating agency. He meets up with a Korean lady who they get married, and then the Korean lady, he gets dementia and is in a aged care facility, and he's about 82 or something. All of a sudden, the family apply to the court because this Korean lady has moved $3 million of his money overseas and spent it on property over there in Korea. So she won't bring the money back to Australia. So the court say she's in contempt of court and commit her to prison until she does bring the money back. So courts have got these powers. They don't use them, I guess, maybe often enough. Anyway, so then the son applies for the will to be, because what happens is that when you marry someone, your will is revoked. So unless it's made in contemplation of the marriage, it says it in the will. So the will was...
So as soon as you get married, new will.
New will, unless the will says it's in contemplation of marriage. I had one the other day. What happened here was that the Korean lady married this man, and therefore his will was cancelled. What the court did was reinstated the previous will, or had a new will done in the same terms. So in fact, his family got the money, and not this poor Korean lady.
But he must have given access to the money to his wife, otherwise she wouldn't have been able to.
Of course she did. Of course he did. I guess did he give access? It's difficult to know how she got her hands on it. Maybe he did, but remember, he might have had dementia. I guess in the throes of love, even though you're 82, then you can do things which can be quite.
Love.
Love conquers. Yeah. Okay, where are we now?
Number 9, I think.
Number 9, all right. Pretty pleased this is coming to an end. Okay, right. Number 9 is this.
Don't you like talking to people?
Oh, no. Number 9 is kind of interesting in that it used to be that people would make wills and say maybe murderers, they used to get hanged, thieves used to get their hands cut off, so everybody knew exactly where they were. A few mistakes made, obviously, but you had certainty. Same with wills. Wills had to be made in the presence of 2 people who had to be present at the same time, who signed in each other's presence, and the testator at one stage had to sign at the foot or end thereof. Those things didn't happen. Will thrown out went in accordance with the rules of intestacy. Now the courts are saying, look, maybe we were a bit too harsh in the centuries gone by, and now we'll accept something less formal, providing it's the intention of the testator. Well, of course, it's nice to do this, but can you imagine that if you had the formal will and you had the 2 witnesses and you had it all signed up and you're going to get the money, and all of a sudden there's some sort of scrap of paper that was produced when he was in some sort of drunken sort of state, so giving the money to someone else, would you be happy? So what happens is that nowadays there's been a will admitted on an iPhone. There's been a will where a CD in his in his papers said will on it, and the court actually accepted that.
Right,
so,
and on an iPhone.
on an iPhone. So this is just So you can imagine the sort of disputes that are going to arrive. For instance, it's not a bad idea if you're left out of a will to have a good look through the person's papers in case you're going to find some scribbling which might actually leave the money to you. So anything you do like this does cause. Obviously, it's fairer to leave it to try to follow the testamentary intentions, and these wills have to be well proved because the court are not not stupid, but when you're dealing with other people's money, you can be a bit more generous than with your own money. I'm sure if the judge had a stake in it, you would maybe a bit harder to convince.
Oh, the judge doesn't have a stake in it.
No, he doesn't have a stake in it. No. And often lawyers, their whole thing is to try to avoid going before the judge because you never know what they're going to do. You have a good idea. If you ever listen to a judge summing up a case, I think they do it deliberately, on purpose, in terms of you're never quite sure which way they're going to decide. And they can talk for about 20 to 30 minutes, and then finally they come down on one side or the other. And obviously, it's a difficult time, especially if they don't come down with your view.
A couple of years ago, I was following a case with much interest, and I was just so surprised that it went the other way. It wasn't nothing to do with me, but it just sort of, the law sometimes can be an ass, as you're saying.
Well, normally if they decide against you, people don't like it. But often lawyers, what they try and do is get to a stage where this is the law and coming to some agreement at the end of the day, not having it go before a court. I've been involved in various trials. It's very stressful, even day by day. One day you can think, well, you really did a great job one day, and the next day you can be really down in the dumps. And, judges are only human. They do try to do the right decision. But even when you're in a trial, the judge will be constantly hinting, he'll be trying to get the issues into a way where you might go away and decide yourself, because it takes the heat off him too, because he might be appealed to the Court of Appeal who say, what cowboy's been at this, and he gets it in the ear. So no one really, people would prefer a settlement deed. That's what lawyers, hence the reason in the old days you do go for 3 years, and really at the end, the barrister who gave such sort of great advice and firm and aggressive advice when you're sitting in his chambers, he's not so brave and aggressive when you get to the day of the hearing, because he actually has to argue this, and someone wins and someone loses.
Yeah, absolutely. Number 10.
Okay, number 10 is just general. Just have a thought for those left behind. Look, as you get older, you're not maybe thinking as straight as you were. So try and make a will a little bit early. Don't leave it like I was out to someone's deathbed. I had to go into their house. It's not very nice. There's their lawyer trying to get them to sign a will. I remember saying to this guy, I said, how are you? He says, I felt better. And his children, his sons took him up and walked him around the garden for the last time, and he died. But it shouldn't have been a case where you kind of wait, because people tend to do this when when you're at the hospital and the guy's in the hospital bed going, you're having a cigarette or whatever, you're saying, well, has he made a will? And all of a sudden there's this call to the office, and you get some solicitor running around like a blue-ass fly to make it a will.
It's a crazy world, isn't it, that we live in? But look, I was really looking forward to this interview. Thanks very much for talking with me, Paul. I find I've heard you talk several times, and if you're ever here if you live on the Sunshine Coast and haven't heard Paul speak, I can absolutely recommend going on along and listening to him. Paul, just in closing, what would be the most fascinating, interesting, sort of left field type case that you've ever heard of?
I've ever heard of? I think that there was a case in India which I think it lasted about 300 or 400 years. So it was some ridiculous amount of time that it lasted. And of course, the problem with a case like that is that the defence and the judge, everybody keeps dying, so you have to kind of renew things all the time. So, but obviously nowadays cases take about you could be up to 3 years or maybe 18 months. There's less cases now. I think that mediation has really helped reduce the length of cases and try to get to the issues. Courts are managing cases a lot more now. It used to be the judge would sit back and let the parties go on, but now they kind of get on your case.
Fair enough. So if one wanted to connect with you, Paul, what would be the best way to connect with you on social media, Facebook?
I think
website?
Look, I've got a website. It's brennanlaw.com.au.
Okay. Great, Paul. Thanks very much for talking with me today. I appreciate that. And no doubt we'll talk again soon. Have an awesome day.